I did a deep dive back. The same bill sponsor, Assemblywoman Kahano, had actually put this up back in 2011, 15 years ago almost to the day. This bill was up, and at that time, the Assembly vote came out 46-32 against, and never made it to Senate committee. So I did some research. I pulled some of the commentary back then, and what's interesting to me is, as Assemblyman Rumpf said, the GOP did reference the Croson decision. So if you're not familiar with it, it's where the court said the government doesn't get a free pass to treat bidders differently based upon race or sex. And if government wants to do that, it has to prove there is a compelling reason with actual evidence and prove the remedy goes no further than necessary. That's the exact language, no further than necessary. So our good intentions aren't enough. The evidence has to justify the action. So those concerns raised 15 years ago are still the law. The legal standard didn't change, but what did change is New Jersey came the disparity study that the chairwoman did reference. And the sponsors of this bill claim that the disparity study satisfies the Croson requirement. But the real question is whether that study is strong enough to justify race-conscious or gender-conscious contracting preferences, and whether the remedies are narrowly tailored enough. So that's the issue before us, not whether discrimination is wrong, because it is, not whether barriers should be removed. They should be. I'm a woman sitting here saying this. But the question is whether government gets to classify people by race and sex, and whether this legislation has assembled enough evidence in 15 years to justify doing so. And supporters want us to believe that the disparity study answers the question. Maybe it does, maybe it doesn't. But we should recognize what happened here. This study was not created in a vacuum. To explain the disparity study a bit, it was commissioned with full knowledge of Croson. The study itself references Croson multiple times. It discusses constitutional standards, talks about exact findings necessary to defend race, gender-conscious remedies in court. So in other words, the constitutional obstacle came first, and then the study came after to meet the constitutional standard. So I think it's fair to ask whether the evidence led to the policy or whether the policy led us to search for the evidence, because we should start with preferred policy outcome and work backwards, looking for evidence necessary to defend it. What worries me is we're being asked to accept the conclusion that because the study exists, rather than asking whether the study justifies the conclusion, is problematic. A burden isn't on opponents to prove this unconstitutional. The burden is on the proponents, the bill sponsors, to prove that it meets the standards and the classifications that are constitutionally necessary. After reading the entire bill commentary from 15 years ago, I remain unconvinced that this burden has been met. For that reason, I vote no. Thank you.